One of the most contentious and contended elements of the TPP is the ISDS, the Investor State Dispute Settlement. In short, this grants an investor, a corporation for example, a mechanism to use dispute settlement proceedings against a foreign government. It's a court of sorts, but conferred by the powers of the TPP and outside a country's court system. The question is, how binding is an ISDS decision? Does the TPP compel governments or corporations to act on what an ISDS rules? And if a government or a corporation rejects an ISDS decision, how do they appeal it? Can they appeal it? Now, I asked Trade Minister Todd McClay these questions last night. If you missed it, here's about a minute of his reply.
Extremely comfortable with where it's landed.
What goes wrong? Is there an appeal process allowed for under this?
There are significant numbers of safeguards that have been built in.
Minister, is there an appeal process allowed for under this?
Ultimately,
is there the right of appeal, and is there someone to appeal to?
So ultimately, the final appeal that could take place if a government and any one of the TPP countries didn't agree with an outcome is that within the agreement, the sovereign right to withdraw from that agreement or to make changes. So, John, the very important thing to focus on here is not whether or not ultimately a court or something else can make a decision. It's the likelihood of that happening and whether or not in the case that it's justified, we have the ability to defend it. With the exclusions that have been put in place, that tobacco can't take a case, that we have the right to make any decision.
That exclusion is going to remain. That exclusion, you're absolutely certain that exclusion is going to remain? You give us your word on the radio now that tobacco exclusion is going to remain?
I will be signing the agreement on Thursday, and therefore, as part of the legislation we put through, that was the commitment as far as New Zealand's concerned.
That's Todd McClay from yesterday. So the question remains, are there formal appeal provisions that go over and above the ISDS forum? We asked Mr McClay's office to cite the provisions in the TPP deal. We haven't heard back from them, so we went to an expert in American public law. Alan Morrison is a professor of public law at George Washington University. He's previously taught at both Harvard and Stanford, but perhaps more importantly, he's also argued 20 cases before the US Supreme Court, specialising in public law. Now, in an article for The Atlantic magazine, he argues, and I quote, TPP arbitrators will decide what is essentially a legal question, whether government actions which are designed to protect our health, safety, environment and economic well-being are consistent with the TPP. And if governments don't like the answer, I asked him if the TPP does contain a formal appeal procedure.
There is no right of appeal from arbitrations as we know the right of appeal. Indeed, the ISDS makes it pretty clear that there are no appeal rights. It is conceivable that in an action to enforce an arbitration, there are some limited review, but I can't imagine the United States government forcing a company that's won an arbitration against it to go sue them. The government would just pay it. So I think as a practical matter, there is nothing in the ISDS or anything else placed in the TPP to provide for an appeal. And so I guess the answer is no. There is no appeal.
So there is nothing in the TPP agreement that provides for an appeal after an ISDS ruling?
That's correct. I assume by appeal you mean a situation in which a group of judges, whether they're international judges or New Zealand judges or American judges, can review the decision as they would review a decision of any other tribunal, meaning they look at the facts and review them at least to see that they're properly found, and they review the questions of law, including the constitutional questions. And there is no such provision for that. Indeed, the whole point of this is to keep these cases out of the domestic courts of New Zealand, the United States, and all the rest of the signatories.
If we look at your article in The Atlantic, and the question the article begins with, the headline in fact, is the Trans-Pacific Partnership unconstitutional? What's the answer to that question?
Well, as you probably know, writers have very little control over people who write the headlines.
Yes, I do know that.
I'm sure you have some of the same painful experiences I have. This is not so bad, but I have never contended that the Trans-Pacific Partnership Agreement as a whole is unconstitutional. What I argued is that the dispute settlement, the ISDS, is unconstitutional because it's being done by private persons. There's no right of appeal to the courts. The private persons are also individuals who represent investors in various other contexts. And overall, it just doesn't fit with our system under which neutral judges are supposed to decide important questions, including those arising under treaties and laws of the United States. And I think it's unconstitutional in that regard, and have so said on a number of occasions.
Alan Morrison, public law expert now based at the law school at George Washington University. Now, as we discussed last night, the European Union is also in negotiations to have a form of, well, a similar kind of trade deal with the US, not trans-Pacific, but transatlantic. But the TTIP will almost certainly not contain the ISDS dispute settlement mechanism. It's been rejected entirely by European negotiators. Here in 30 seconds is Anna Fielder, Senior Policy Advisor of the Transatlantic Consumer Dialogue, explaining why.
We do not like investor-state dispute resolution mechanism. We want it completely out of the agreement. We don't see why in advanced democratic economies with advanced judicial systems you need a private court to arbitrate on government rights to regulate. So for us, ISDS is out.